Ladies and gentlemen, Joy Stephen from the Paulins Studios, another case law, Navaratnam versus Canada, immigration case law, refugee status, procedure. Refugee claimants were citizens of Sri Lanka who alleged fear of persecution by Sri Lankan authorities and paramilitary groups. Claim was heard in March of 2013 by RPD, or the Refugee Protection Division, member who became ill prior to rendering a decision. Claimants were given option of de novo hearing or of having another member decide their claim based on evidence, submissions previously made and transcript of the proceedings. Claimants chose the second option but contended that counsel had requested that he be provided with hearing transcript in advance of any determination by new member. Transcript was not disclosed, and significant portion of reasons was devoted to question of criminality. Member concluded that principal claimant's evidence was not credible and was therefore insufficient to support claim. Member concluded that principal claimant was not convention refugee pursuant to S-6096 or person in need of protection under S-97 of the Immigration and Refugee Protection Act of Canada. Claimant applied for judicial review, contending that member breached requirements of procedural fairness and natural justice by failing to provide them with a copy of the transcript prior to rendering in chambers decisions that they had requested. Claimants contend as a result they were denied fair hearing and they had no opportunity to speak to members' credibility concerns. Application was dismissed. Failure to provide transcript prior to new member issuing his decision did not result in breach of procedural fairness. Parties identified no RPD rule or another process that applied in event that member who had conduct of hearing was unable to render a decision. It was therefore open to RPD to offer claimant's choice that it did either hearing de novo or in chambers decision by another member based on transcription of evidence led and presented at hearing. There was no evidence as to whether coordinating member agreed or did not agree to claimant's counsel's request for transcript. Claimants had benefit of full hearing before member to which they were represented by counsel who made submissions on their behalf, orally and in writing. To extend that credibility was raised as concern at that time, it could have been addressed. Record does not indicate that request to make post-hearing submissions on credibility or any other issues was made by counsel who attended hearing, and there was no evidence that RPD agreed or would have agreed to new submissions based on transcript. Indeed, in normal course, claimant could not be entitled to be provided with, review and respond to hearing transcript prior to decision being rendered. Interesting case on refugees, Navaratnam versus Canada. The judgment is posted in my blog, reportersreport.com. Thank you.